Well, Bonesy, looks like I'm late for class. I don't think anybody else is going to show up. Sorry to bail on you like that, guys. What I thought to make it up to you is that we could go through this lecture through using Moodle, and if we have time, we'll do some of the interactive activities on the last day when we're doing review, because they'd be good as a review. That way you don't have to spend extra time at school, but you still get the material covered. Let's pick up where we left off when we were looking at the CMTBC bylaws up on the hill. So we're on page 39 of that document. Registration exams are set out in Schedule B as far as the fees for the various registrations or rewrites if needed. When we're talking about a certificate, it's important to recognize that both the certificate of registration and the registration card that you get, which is similar to a little debit card, are actually the property of the governing body. And so when you retire, those must be sent back. You can always ask for a token certificate where they'd actually just put a big stamp on it that says retired and then send it back to you, which is actually what I did when I left Ontario. It's important to remember that in our structure, there is only the active class of registration. We don't have specializations or any multiple tiers like an MD would when they went into surgery or anything of that nature. So the registration card will have an expiry on it, and you'll get a sticker every year, and you'll just put that sticker on top, and that shows that it's now valid. Limited liability, you are required to have $2 million liability. This doesn't mean that you spend $2 million. It's how much you're covered for. Do you remember we talked about the two types of liability that you must have? So malpractice and general. And malpractice is if you hurt somebody. General is if they slip, trip, and fall on their way into your facility or while in. So what you'll find these days is $5 million is fairly standard for our industry. So even though you're only required to have $2 million, you'll get a policy that'll be for $5 million, and it'll cost you about $135 a year. And that's something you do have to buy every year. Here is a trick. So this is not found everywhere, but in BC, if you are not getting an occurrence-based policy, now the policy that you're getting through RMTBC is occurrence-based, but if you chose to go with something else, you have to have at least 5 years of insurance, even once you're retired, in case anybody sues you for treatments that were done while you were still a massage therapist. So you can get insurance elsewhere, but just make sure that you do know the difference between the claims base compared to an occurrence base. Occurrence base is the one that you really want. You must provide the college with relevant employment information. So the address of where you work, the telephone number, names of employers, email address, all of that. If that changes, you have 7 days to report the change. That form looks like this, and you can find it right there. Now, we talked a little bit about the Quality Assurance Committee, and part of their duty is to make sure that therapists are participating in continuing education. So in British Columbia, we have a 2-year cycle. It begins November 1st and will conclude 2 years after that initial cycle begins. You must obtain 24 credits, which actually in most cases ends up being 24 hours in that 2-year period. That is not an unrealistic amount of education to acquire every 2 years, and hopefully you have enough questions about the profession that this is just naturally something that occurs. If you are not compliant, there are fees for that, of course, but really it's not an unrealistic request. One thing to be aware of as new grads, there is a blackout period. So if you become registered, let's say January 5th, from January 5th until October 31st of that first year, you are in a blackout period and it doesn't count. So you can do continuing education, but it won't count in your 2-year cycle where you need to have your 24 credits. Just something to be aware of. One thing that you must do that has changed recently, you must continue to be certified in standard first aid. So they're requiring this from all of your traditional sources, whether it's Red Cross, Ski Patrol, Heart and Stroke, St. John's, there's a bunch. But know that that is something that in the past didn't necessarily have to be actively maintained. It does now. With regards to the duties of investigation and discipline, remember those were two separate committees we talked about. Within investigation, inspectors are charged to visit registrants when needed, but they must obtain special consent if they are to observe when a patient is being treated. That's not part of a normal inspection. Mediation is something that's a really great idea when we're looking at cost effectiveness. So the cost of investigation and formal discipline hearings is quite high, as we talked about the other day in class. Mediation costs far less. So we have the complainant, the therapist in question, and then a neutral third party, which is much more cost effective, trying to come towards an agreed statement of facts. So the mediation, again, is part of that investigation and discipline procedure. And sometimes you will have a formal citation, which is that legal letter for an RMT to come before a formal disciplinary hearing. So we're just moving to page 45. A discipline committee does have to notify the registrant with a minimum of 14 days prior to making that order to appear. And if anybody is involved in the matter, they cannot be standing on the inquiry committee or the discipline committee because there would be a conflict of interest. All of the discipline hearings will be recorded as well. So if there are any limits or conditions or suspensions or cancellations of registration, this has to be notified to all other registering districts in Canada. So the other regulated provinces would need to know about the disciplinary hearings' final outcomes. And on request, it may also go outside of the country. If a registrant is suspended, they cannot provide massage therapy, they cannot hold an office at the college, and they cannot communicate with their clients other than to say, I'm no longer able to treat, I'm suspended, whatnot, or advise them of who is going to be taking over the clinical practice. They must remove their signs and they must surrender their certificate of registration, as well as pay any fee that's been assigned. We're now on page 50, where we're looking at Part F of the bylaws, the advertising and other marketing activities section. Hopefully you've come across this as you've been going through your marketing projects already, but let's touch on some of the highlights. Marketing activities cannot be false, inaccurate, misleading, or not verifiable. I know it's rocket science, right? If an activity takes advantage of or creates or implies that a registrant would obtain certain results, like just 2 treatments a week of this skin rolling will remove the cellulite from your thighs. Not achievable. Not okay. Not all right. We must not tarnish the reputation or image of the profession, and it must be dignified and in good taste. It must not suggest that the service is provided something that's other than what's within the scope of massage therapy. And you can in no way, shape, or form say that you are speaking on behalf of the governing body. Now, endorsing a product or service, this is interesting. This is province specific. We have a bit more flexibility in BC, which is kind of interesting. So you're not to endorse or lend yourself out as a source of education or knowledge on something unless it directly relates to the profession of massage therapy. So this could be a massage table, it could be lotions and gels, it could be TheraBands or other sorts of materials that you would use within your clinical practice. Just be aware that once you're getting into nutritional information, golden retrievers, real estate, not okay. Has nothing to do with our practice. They remind you that you may not use the title of specialist. You may not use techniques that you are not trained for and are outside of the scope of practice. A method of phrasing rather than saying specialist would be to say preferred area of practice or clinical focus. That way it is not denoting that you have a specialization. Advertising, if you are doing services that fall outside the scope of practice, also have specific guidelines. You are not to advertise these together. They want them to have a clear separation of the professional services. So that means separate letterhead, separate business cards, separate accounts, And you cannot use the same billing as you would for massage therapy. So your RMT number that you'll be assigned once you graduate and have registered cannot show up on a bill of sale for services that are not massage therapy. There has to be a clear differentiation. This has been something that has been trouble for some therapists, so it's worth working through ahead of time and making sure you know how you're going to handle it if this is something that applies to you. Now, if there's dual registration means you are a part of more than one governed body. So this is not saying that you do Reiki and RMT. That would be this. Here we're talking about another registered profession, so a nurse, a chiropractor, a physio, as well as being an RMT or a naturopath. In these cases, you also still have to have a clear differentiation and separate business letterhead, business cards, statements, and as well using the proper occupational title on all of your billing information. When you're advertising with others, whether they're registered or not, they encourage and require that you have a clear separation between the services about what you offer and what the other individual offers so that the public is not confused. So if you're working in a spa, for example, and you have unregulated estheticians who are offering spa massage or facials or that, and you're there as well, there has to be a clear understanding of who is the regulated therapist so that the public understands who they're going to. You also have to hold on to your advertisements or marketing materials for a period of 1 year. So this needs to be any publications, electronic media, anything that was written or that was broadcast, and it's your duty to make sure that these statements are available should the governing body ever require them. Now, normally I would take a show of hands as to any of you who are looking at becoming a corporation when you start your business structure. You can do this. In the past, it wasn't something that was allowed because they want healthcare providers to be very transparent, and a corporation allows some sheltering and some hiding. However, they have specific guidelines now that do allow healthcare practitioners to be corporations, but there are some additional rules. So you have to apply for a permit. You do have to ensure that everybody who has a controlling interest in the corporation is an active registrant. So in this case is an RMT. And then, of course, you're going to pay more money. Now, each permit has to be reapplied for every year because they're only valid for 1 year at a time. And lastly, on page 57, we have a little bit of information about supervising and delegating. So a registrant can delegate massage therapy as long as the therapist is abiding by the standards and limitations and is being appropriate to the conditions, as long as they're being directly supervised, kind of like you guys are in clinic. So now we're into the additional schedules. Schedule A, we don't need to take much time with. These are the schools that are licensed in BC and are recognized so that once you get your diploma, you're able to go in and do your provincial board exams. You'll be happy to see our school is second on the list. With regard to Schedule B, the one that you have was from last year. This year we've had a few increases. So initial registration is $500 this year. Same thing with renewals. Your exams are $1,200. I'm sorry. And there's been a few other, when you repeat one aspect of the exams, those numbers have gone up as well. On the upside, they're still listed separately, which means if you fail one piece of the exam but pass the other, you're still only going to have to pay the smaller amount rather than have to pay the full $1,200 over. And when we get to Schedule C, you'll see that it's been repealed. So what, pray tell, was this Code of Ethical Conduct? Well, it's so last year. So CMTBC has actually come up with something new. So very similar. Their Code of Ethics now indicates just a little bit, and you can't really see anything right now, can you? Sorry, guys. This is on Moodle, so you can download and need to download a new 3-page section for what was initially printed for you. This actually came out just a couple weeks ago. So in the new Code of Ethics, there are expectations for ethical conduct in your practice, and this means that all therapists are responsible for exercising their professional judgment. So you're trained not to just follow instructions that CMTBC puts out, but also to use your decision-making skills that you've gained in school. And that's actually a primary duty within being a registered therapist, is to be able to think on your feet and make good decisions. So a conflict of interest is where you're acknowledging the therapist's personal interests or interests of any person that's closely related to you or associated with you, if there may be any influence or could be perceived that there's an influence in how you would treat another person because of that. Former patient is just talking about somebody who you've treated therapeutically in the past, but that relationship is now terminated. And I think we're all clear on sexual misconduct. So whether that is sexual intercourse, touching, behavior, sexualizing a treatment, anything, totally not okay. Your duties to your patients include to act on the best interest of the patient. This is not a great surprise. A massage therapist must recognize and disclose any conflicts of interest that they have, treat everybody with respect, not participate in fraudulent billing activities. Again, rocket science. They must respect human rights legislation and only treat if there is realistically a reasonable benefit that the individual is going to receive from what you do. You must provide complete and accurate information so that the person can actually make an informed decision whether to have or not have the treatment and obtain that informed consent. So just providing the information is not enough. Getting them to say yes is not enough. All of it has to be there. So the risks, the benefits, the side effects, alternatives to treatment, all of it. As you get into second year, this is going to be a huge part of your CTP class that you will have 3 times a week. So get into the habit of good consent in all the exchanges that you do. It's a primary important piece to the boards. It's something that has been emphasized much more so in recent years. So it's something that we're really pushing as well. So you must not claim to cure or guarantee a therapeutic value to something. We are not snake oil salesmen. Everybody will heal or not heal at different rates based on their pathologies. A therapist must practice only within the limits of their knowledge and skills. A therapist is responsible for their continuing education and must recognize their own limitations. They must not treat while impaired by alcohol and drugs or cough syrup, right, guys? Also, they must refer when it is in the best interest of a patient. So that is to another colleague or someone in another healthcare professional setting, like a chiropractor or a physio. We must abide by all applicable laws and avoid revealing any confidential information. The best example I've ever heard of this, where it was accidental, which was where a group of therapists would get together and they would go for breakfast at a place like a Denny's. So it was very busy. And unfortunately, the one person was really excited about a case that had come up in their clinic, and she shared this with her peers, but the case was unique enough, being a small town, that it was identifiable. So even though she didn't give the person's name, she gave enough personal information that their confidentiality was not protected. And of course, it ended up being an issue and a lawsuit and all the rest. So just something to bear in mind. Also important to maintain appropriate professional values and boundaries. Make sure we do not take advantage of the patient. Massage therapists are not to engage in sexual misconduct with a patient. Yet again, unfortunately, this means it's been an issue. Therapists must refrain from any close personal relationships with a former client unless a reasonable time has elapsed, which would be, that's right, about a year or more. And also that there's a satisfaction that the power differential no longer exists to a point where it would be a problem. So as we've talked about before, we also want to make sure that there's ongoing continued therapy for them with another practitioner, that they've initiated it, but this is some bare minimum precautions. Massage therapists must continue to treat a patient unless the therapy is no longer indicated or the client doesn't want it, unless somebody else has been brought in to assume primary care, or if they've been notified in writing of the intended termination. Now, that goes without saying. If the individual is sexualizing or attempts to sexualize the treatment or threatens the therapist in any way, of course, you are allowed to immediately terminate the therapeutic relationship. They're never asking you to put yourself in a place of danger. Therapists must comply with all applicable laws and regulations. Yet again, being very clear, the public and the private healthcare resources that we have access to must be used prudently. It goes hand in hand with no fraud. We need to recognize that self-regulation is a privilege, not a right, and we must handle it with respect. Anytime that the college will ask us for information, we must respond to them in a timely manner. Therapists must conduct themselves in a manner that is respected by society, whether it's other therapists, our own professional therapists, or the members of the public. And we must collaborate with other health professionals as is appropriate and participate in peer reviews and mentorship. Lastly, this is kind of cool. Therapists have to protect and maintain their integrity. So an example of this, have you ever worked somewhere or had a family member or a friend ask you to do something and you leave the situation going, ugh, I hope nobody figures out or ever knows that I did that for them, because you got this stone gut feeling about it? That's not having integrity. The governing body is actually asking you to make sure that the decisions you make are ones that you can go to bed and sleep easy at night. So their goal is that your career is only leaving you with good feelings. That's pretty awesome as a baseline. We're also asked to maintain our personal health and well-being. Brilliant. And that we seek assistance if we have personal matters so that we're in a good place when we're performing our duties for our patients. Looking at Schedule D, here we're talking about the standards of practice. So again, a lot of this should just confirm that what you're doing is correct and everything that you need to be doing. So a registrant must assess, do a health history, observation, palpation, movement assessment, neurological assessment, talk about referred sensation and any special tests in order to formulate a treatment plan, and monitoring vitals is a part of that as well, just like blood pressure and pulse. With regards to treatment planning, we need to look at designing and implementing a management plan and a treatment plan. So how are we going to help them with today's complaint, and how can we help them moving in the future as a long-term treatment? This has to include home care as well and activity of daily living corrections. So one thing that you're going to be expected to do at the provincial boards is do 1 stretch, 1 strengthen, 2 activities of daily living, as well as a hydrotherapy home care. This is the basic requirement for assigning home care. So maybe as you're getting into your outreaches, start practicing this. It doesn't mean that you have to assign all of it to your client each time, but it's an excellent exercise for you to get used to continuing that process of thinking through what would be appropriate in this case scenario. With regards to informed consent, each and every time a patient comes in for treatment, they must be fully informed. Implied consent doesn't work for us because nudity, right? So you can show up to a naturopath's office, you've showed up, that's implied consent, away you go. Not so in our case because of that additional privacy issue. We must discontinue treatment anytime that the patient withdraws consent, not at the end of that treatment, but immediately when the patient withdraws consent. And we must constantly work within and monitor what the patient's pain threshold is throughout our treatment. A registrant has to consult with other registrants and refer to other registrants as would benefit the patient. Patient education means we have to educate the patient on factors that are influencing their health and wellness, but also what they can do for themselves. So at the end of the day, they're not feeling dependent on us. They have to have an idea of how they can help themselves. We do have to have access to peer-reviewed scientific information, such as what we see through the RMTBC and the Case Re3 and all of those fabulous journals that you guys are going to be working with in an in-depth way in the very near future through your research program. You must display the certificate of registration once you have it, and you also have to post your fees. Now, they say this has to be visibly displayed, so that could be within your treatment room, it could be in the waiting room, but regardless, it has to be something that is very clearly outlined for individuals who are interested in receiving your treatments. The procedures for payment, as well as the fees for missed payment, also have to be outlined clearly. You must apply universal hygiene and provide a clean, maintained environment, including equipment that is in good working repair. You have to be able to be clear on the difference between your personal and professional beliefs and behaviors and leave the personal stuff at the door. That includes things like religion. A registrant has to be able to communicate if they have any conflicts, how to resolve them, and have good strategies. So in CE, when we talked about transformational analysis and working through aggressive versus assertive communication, this is one of the standards that we're working to acquire. A registrant also has to recognize that there are different cultural and personal attitudes towards disrobing and be sensitive to this. We also have to respect the rights of the client to decline to remove certain clothing. You guys are quite talented. I have no doubt you could work through a parka. Make sure your clients know that they can stay clothed and you can still do good work. You should know this too. Also know, again, that if a client withdraws consent at any time, you would stop or change draping at that time. Schedule E talks about the ever-important healthcare records and their management. So everything that we do must fall within FIPA, the Freedom of Information and Protection of Privacy Act, and we'll talk about that shortly. We must be able to provide patients or their legal representatives to access to their information. While we safeguard and are custodians of this information, it is the right of the patient first and foremost. We must ensure that all records are securely stored and disposed of. So securely stored for paper files means locked, and disposed of would be shredded or burned. But if they're burned, we have to make sure that there's not big pieces that can float up, because then that information would still be acquirable. There would have to be a grate on top. If it's electronic, securely stored means password protected, and disposed of would be destroyed in such a way that it could not be pulled back up again. So electronically wiping it, but making sure that it's done in such a way that you could not acquire that information back. That's how they outline it. So with regards to records for each patient, you must make them. You do have to generate records for each patient. You also have to maintain possession and control over that record until it can be destroyed or transferred. So there is some difficulty sometimes when you have a workplace that is not owned by a licensed professional, and we'll talk about the different regulated professionals that can be custodians of healthcare files in just a moment. In a case like that, you can transfer the files to another RMT, for example, but you cannot leave them in the care of that business owner who is strictly a business owner, not a regulated professional, because they aren't qualified as someone who can be a custodian of the healthcare records. They haven't taken any oaths and don't have any of those legal requirements. So preservation and disposal. Records have to remain in the registrant's facility or place of business for a period of 16 years. That was a change just a couple years ago. And something that has shown up in detractors that I just want to point out, it's 16 years as of their last treatment, not their first treatment. And sometimes that's a detractor as well. So 16 years from the last time that you ever saw them, unless they're a minor. So if it was a child, you would also have all of the years up to the point that they become 19, and then from there, 16 years forward. So if you're treating infants, you're keeping files for a heck of a long time. If it's a physical record, it has to be shredded or incinerated in a controlled environment, like we already talked about. And here's where they talk about the electronic document. So erasing has to be done where all traces are destroyed and it cannot be reconstructed. If a client is wanting their information, once it is after that 16-year period, you can return it to the patient because you no longer are bound to safeguard it. And you can also transfer records to another registrant so long as the patient has given consent. When there's a sale of a clinic, that's commonly done. And when you're doing so, you have to make sure that you are making appropriate arrangements to appoint another registrant as the custodian. You do have to make sure that records are available for inspection if the college was ever to ask. And if there is a breach, that there's a remedy. This was actually a change in the privacy policies that we have to abide by. In the past, that wasn't something we had to do. It now is. If you have a locum, so a common example of a locum is if you take a vacation or if you're on mat leave. If you have a registrant enlisted as a locum, the records that exist and were newly created during that locum's time, that tenure, remain the custody of the primary registrant. So that's something that sometimes isn't clear in contracts, but you need to know that's legally how the CMTBC has it set up. Registrants must ensure that all services are separate and distinct from any non-registrants, which we've talked about in the advertising section. We must make sure that we maintain the confidentiality of the client as well. So we couldn't, for example, have a shared file where the spa practitioner and ourselves both use Mary Jane's file, because the spa practitioner does not have the authority to work with that file under the privacy legislation that a regulated therapy works under. Okay, on to page 70. So this is the very end. You've made it. A registrant who provides professional services in or through a shared facility has to establish a written agreement confirming that the registrant has the custody over those records and maintain that custody or control over the client files at all times. So by now, there should be a fair bit of clarity between these two different bodies. The CMTBC, and yes, you need to know that acronym, is our college, the College of Massage Therapists of British Columbia. Their primary goal is to protect the public. RMTBC, hint, RMT is in the title. They support the RMTs. They support you, the registrant. So as we go through the notes from Lecture 3, you'll see here that I've highlighted all 4 of the RMT's mandates to educate the therapists, to promote therapists, to empower them, and to represent them. I think that would probably be something that would be worth highlighting in your notes too. Also, that big take-home message that RMTBC represents the registrant. So if you haven't as of yet, please read through the different things that RMTBC does for you. The committees here are, you don't need to know. It's not going to be an exam question on the boards, nor for me. Just know that if you're wanting to get involved and CMTBC isn't feeling like somewhere that you're comfortable, this is another option as well that you can volunteer your time. Now in your notes, you have a blank copy like this. So because we weren't able to go through it in class, just maybe take a look. So moving on to Lecture 4. I know this lecture was only supposed to be number 4, but it's fairly customary, especially when we do something crazy like going out and doing CMTBC up on a mountain side. We do sometimes have some overlap that we have to bring forward. So, Lecture 4 material. We're talking today a lot about privacy policies. So, a couple differentiations I want to make. In your notes at the beginning, I'd like you to highlight that the Personal Information Protection and Electronic Documents Act, PIPEDA, and know those initials, that is a federal act. So that's something that was initiated and is consistent over all of the provinces. Now, when we look at more specific documents to our province, the Personal Information Protection Act, PIPA, was enacted in 2004. It's relevant to the private sector. So what about if you work at a hospital? That's a public sector. What happens then? Well, this would be FIPA, the Freedom of Information and Protection and Privacy Act, FIPA. So both PIPA and FIPA are provincial, whereas PIPEDA is federal. If you can find a fun way to make that stick in your brain, go for it, because you do want to be able to remember those. So just like when we would look through the overhead in class, you have these for you in Moodle, and they are highlighted just like you see them here. So right now we're looking at PIPA, and you can remind yourself whether that is provincial or federal, whether it is private or public. The purpose of this act is to govern the collection, use, and disclosure of personal information by organizations, and to protect that personal information so that you guys can use it and it can be disclosed when it's appropriate. So let's compare that to FIPA. Again, ask yourself, is FIPA federal or provincial? And is it public or private? And we may get some answers here in the purpose. So with FIPA, the purpose of the Act is to make public bodies more accountable to the public and protect privacy, giving the public right of access, allowing them to make corrections, and preventing unauthorized use, collection, or disclosure. So here's an example of the corrections. There was a student of mine who requested information from one of the physicians that saw her within a hospital. She did not like the physician's tone. He made a snap judgment. She felt she had a very fast metabolism, and he made comments along the lines of her being anorexic. And she wanted to see if that was something that he had written in the chart. He did. And she had an ability to see that and also see its correction, and went to her own family doctor as well for the correction to be placed in. She did have a metabolism issue, and it was not part of any mental health concern that she was having or anything else. And that sort of information in your health file you do want to make sure is correct. Also have outlines for protection of personal information, that storage and access must be within Canada only. This has actually become a new issue as far as a lot of cloud services have been in the States. So for us, this now means that we have to ensure if we are storing our documents electronically or we're using an electronic database system like Click for Time, that it has to be stored within Canada, and we need to make sure that that's something in the contract so that everybody's clear. That there is protection for whistleblowers and also notification if there is unauthorized disclosure. So again, we had talked about that in another document in the bylaws, that we do have to let people know if there's been someone who was not allowed to be working with the files, see or have access to the files. This outlines that the patient does have access to the records as long as they're willing to pay a fee. So a fee has to be reasonable. This could be the fee for photocopying the information, for example, or paying somebody to come in after hours to open the clinic and sit with them while they observe it and then lock it back up. There does have to be a written request which provides proof that this person does actually have the authority to have access to the files. A therapist is expected to respond no later than 30 days if they've received a request for somebody to be able to access their files. And when you respond, you do have to tell the applicant whether they are entitled to have that access, and then where, when, and how that access is going to be given. There are some rare circumstances where disclosure of information may not be in the patient's best interest, but in most cases, a disclosure of personal information is reasonable if you've got that consent from the third party. There's a compelling circumstance that's not going to negatively affect someone's health and may actually be positive for somebody's health and wellness, but also if this is something that could be used for further research to have a better evidence-based practice. It is our responsibility with our note-taking to make sure that we've put effort in to make sure that everything that we write is accurate and complete. And if a client believes that we've made an error or have omitted something that's relevant, they do have the right to request us to make a correction. As you may recall from CE, a correction would be to put a straight line over what's wrong, make the correction on top, and then initial it. Initial and date is a really nice way just to make that correction. We never use whiteout, and we never obscure it so you can't see what the original entry was. Moving way down to fees, it's reasonable to charge a fee for preparing the records. It has taken your time, for example, but also shipping and handling. I had a client who moved out to the East Coast. She was in Newfoundland. No, she was in Nova Scotia. And part of the information I had was before a car accident that she had. So her lawyers wanted that information sent to help show that in the past, before the accident, she had never had or never required treatment of her injured area, the low back or whatever it was, treated. It was not a regular complaint. So in that case, I also had to ship information to her rather than just photocopy for her to be able to pick up. In that case, as is in law as well, you are allowed to say the fee for that will be $30 or whatever the shipping handling fees will be, and expect that payment before you send the information that they've requested. That is permissible. So one aspect of your clinical paperwork should include a privacy policy, and this states that the collection, use, and disclosure of your personal information abides by the provincial and federal laws. So, you could do this on your own, or you could just go on to Moodle under Sample Privacy Policy, and you can download this electronically so that you can enter your name where I've indicated you should put your name here. And this will stand up to the scrutiny that's required for privacy documentation. While accessibility isn't something that's law yet in British Columbia, it is in many other provinces. So Bonesy was here today to help me play with a bunch of toys that I brought in for you guys to illustrate some of the difficulties that individuals with various levels of ability may have. For the day that I missed, we had arranged wheelchairs and crutches and a bunch of other things to be brought to the campus. And I was going to blindfold you and make you go through and try to take lockers, like open your lockers and take books out of your lockers and try using the front door or the elevator while in a wheelchair or in crutches, and just get a better understanding for some of the difficulties. Some of the things here, try taking stickers off of a page when you're wearing oven mitts, or trying to put small things in small holes, or, help put a child's toy together. Some of the other challenges would be filling out a health history when you've got vision impairments, and the scratched goggles and the spotted glasses show what it would be like for various levels of visual impairment or cataracts or other sorts of challenges. There's also ties and other writing utensils that, when you have something like arthritis, is actually a fairly accurate representation. The amount of frustration is fairly significant and often surprising to students, and it will change how you interact with a geriatric client, for example, or someone who's got paralysis from a stroke, when you have a better understanding of how difficult it would be to simply take that pen and fill out the health history form. Another thing that we wanted to talk about was SOCAN. SOCAN is the Society of Composers, Authors, and Musical Publishers of Canada. So recently there had been some questions that came into the governing body asking, are massage therapy clinics allowed to use music in their waiting room or the reception area? And here's the lowdown. A public area that has music coming from an actual radio is not a problem. However, if you are using a private CD where you are not paying royalties and it's in a public space, that is a problem, unless it's something that's from before copyright times, like classical music. In a private area like a treatment room, any type of music can be played. It could be streamed or on the radio, whatever. You do not require a license from SOCAN for that sort of music because it's considered private. Now, when we're looking at the Criminal Records Review Act, what they're looking for here is understanding if there is an outstanding charge relating to an offense or a specific offense with an individual, and making sure that there's notification if there is an outstanding charge relevant to the offense that is notified to the governing body so that they can evaluate that when doing the registration for that person. A record check, a criminal record check, is something that has to be done before your registration so that that can be considered by the governing body. What they're looking for is to understand whether the behavior is relevant as far as does it pose a risk to children or vulnerable adults. The circumstances of the offense, including age, is also taken into consideration. So if there was a B&E when you were 13 years old in foster care, that is something that's evaluated compared to if there was a spousal abuse claim last year, right? They're considered in very different ways. So anybody who is a registrant of a governing body must have a criminal record check done. They also must make sure that that is something that is kept up every 5 years. And that's actually one of the components when you are applying to become registered. So you've passed your board exams, you've got to do a few things. You've got a checklist. One of the pieces on the checklist right before paying your insurance and paying your fees to the governing body is to submit the criminal record check. Now, here's an important piece of ownership. If there is a new conviction or a new charge that would become part of your criminal record, you are obligated to notify the governing body of that change and authorize them to do a new criminal record check. The onus here is on you. It doesn't necessarily mean that this would be something that's relevant to you becoming a risk to at-risk adults or children, but your ethics, if you hide it, the ethics that reflects is not a good representation of the professional code that you have promised to. You always are to submit any criminal record activity to the governing body and allow them to assess whether that's something that is relevant or not for you. So you guys, why did we ask you guys to have a criminal record check done? Well, because we have to. So every educational institution where a student is potentially going to work with children or vulnerable adults, like many of our outreaches and our community events, must undergo a criminal record check. And likewise, if you guys were to have something that came up while you are in school, you would be responsible to tell us if there has been a change and allow us to promptly get another criminal record check done so that we can evaluate whether that's a risk or not. We've already gone through the Medicare Protection Act and the Healthcare Consent Act, but here in your notes is, again, just the highlights from what is really, really relevant in the Healthcare Consent Act, and this is everything that goes into making informed consent. And while it's not something we have to delve into in depth, I did want to quickly bring up the Adult Guardianship Act. Here, they're talking about an adult. This sometimes comes up as an elder. An adult is anybody who's over 19 years of age, and an elder isn't necessarily by age, it's more based on the likelihood of them being abused. So what type of abuse? Well, this could be physical, mental, or emotional damage, or it could be financial damage with respect to their financial affairs. So there's a lot of room for movement here, but it can include humiliation, intimidation, assault, over medication. There's lots of sort of ugly pieces here. It's unlikely that you'll see something of this nature, but just so that you have an awareness, this would be somewhere where you would go for information, and it is something that you would report. Looking at the other end of the age spectrum, the Child, Family, Community Services Act also has similar information where you are obligated to promptly report any information or disclose information that would be damaging for a child. And just like in many of the other acts, we see that no damages are going to be brought against you for sharing that information, even if you shared what you thought was true, but you weren't correct. And I think we talked about the Labor Mobility Act, but just to recap quickly, this is the one that allowed me to transfer out here to BC fairly easily. So it states that anywhere in Canada, this agreement is between the provinces as well as the territories, that a worker who's certified in one regulated province can practice the same profession in another regulated province, so long as the equivalent class is there. So one example, in British Columbia, we have psychiatric nurses. That isn't something that's necessarily in other provinces. So a psych nurse in BC couldn't get a job as a psych nurse in Ontario if that job doesn't exist. In massage therapy, any of the 4 regulated provinces do have massage therapy, so that's somewhere we could go. And remember, what are the 4 provinces? BC, Ontario, Newfoundland, Labrador, and as of December of last year, New Brunswick. All right, guys, so that's pretty much it for today. The quiz for next class will be about what I just talked about here. The quizzes always can go back and talk about some of the other major concepts from past lectures, but are often, I want to say common sense, but you know, if you've gone over the material at least once, it should ring a bell and ring pretty true. The quiz for this class that we missed, that we would have done at the beginning, I'm going to put up on Moodle for you, so you have an opportunity to write that. It'll be open for probably, I was going to say a week, but probably 2 weeks. Okay, so you have an opportunity to get those marks in. Thanks so much, and I'll try to show up for class next time. Next class, we're going to talk about making money and how you can make money if you're working with ICBC, WorkSafe BC, or some of the other more form-based rather than just direct client pay forms of making income or working with clients. And we will be assigning your second project. So you're going to be handing in your marketing assignment, and you're going to be beginning for 72 hours the production of either a WorkSafe document or a physician's report, and we'll go through that scenario in class, and you'll have 72 hours to report that back to me by email.